Can you break it up and do a sign?
What's going on? Oh, trying to survive in a hostile work environment. Barely making it. You come down from Sacramento? What time do you get up in the morning?
Okay, if I could have your attention, we are going to get started now. So if I could have everybody quiet down. Okay. Good morning, everyone. For those of you who don't know me, my name is Joseph Carlucci. I am a senior trial counsel. I'm one of the training coordinators, along with investigator Charlie Hummel. I want to thank you all for coming this morning to our year in review, review department, year in review, appellate year in review, lessons learned. It's gone by many names over the years, but it is, regardless of the label, it is our annual look back on the review department's opinions over the past year. Although the Supreme Court is the ultimate authority, the fact is that our review department is not really at this point the primary lawmaking body when it comes to case law. It is the lawmaking body. The last time the Supreme Court took up an original proceeding was 2005 in Ray Silverton. So it's been a long time. So it's important for us to pay attention and to learn from what the review department is putting out in terms of its opinions, both published and unpublished. And today we have members of our appellate team, all senior trial counsel up in San Francisco. We have Manuel Jimenez. To my right, we have in LA, Kimberly Anderson and Alex Hackert, and they are going to take you through the main lessons learned and practical takeaways from the past year in the review department. So thank you to you all for coming, and a special thanks to Manny, Kim, and Alex for putting this together for you all. Thank you. If you have any questions, let me know. We'll share the mic.
All righty, my name is Manuel Jimenez. Believe it or not, for those of you that have been around, you know me. Let me thank you for spending a couple of your precious hours, especially during this time of year, to sit here and let us review and analyze and review with us the great work of this office. But before I get into the substance of what we do here, I'd like to thank some people, and again, Kim Anderson and Alice Hackert for their participation and contributions in shaping this presentation. I'd like to thank Alan Blumenthal, Kevin Taylor, and Joe Carlucci, who argued many of the cases we're going to be talking today, and who were generous with their advice and expertise. And of course, last and most actually, Brandon Tatey, who prepared and argued 9 of the cases we're going to be of the last year, 2 of which were published, 2 of which the office thought were so important that we sought publication, and his contribution constituted the largest contribution of the canon of this last year. For some reason, I'm looking at my face here. I'd rather not do that, but if that's the way it's going to be, that's the way it's going to be. Okay, the work we do here is important. That is the punchline here. The work we do here is important, and it is important that we as individually and as an office strive to continuously improve our work product, our service to the public and our mission, our counsel, and our representation. And at this present time, we live in interesting times. We have a dynamic environment of change, which for the state bar is continuous. But now we have relatively new hearing judges and a lot of new staff. And the review department decisions not only guide how we approach the law, but also it appears that it affects how the hearing department handles the matters as well, and can have a profound and quick impact. And I'll discuss that a little bit later. The guidance that the review department offers can often be abstract. And as a former manager here used to say, it would be like going to the Oracle and saying, "Oracle, tell us what to do." And the Oracle would say, "The wind blows from the east." So sometimes it's hard to interpret what is being said, and the opinions and statements here are not the definitive opinions and statements of what has happened or how to interpret the law, but it is the ones that we have formulated. You're, of course, welcome to reject anything that you don't think helps. As you will notice, there's no PowerPoint incorporated here. I heard from a lecturer once that those who have PowerPoints often have no power and rarely have a point. And it's a lot of hard work. During the presentation, please feel free to ask questions and seek clarifications. Don't expect an academic response from us. There are people in the office who, particularly me, I'm not an Alan Blumenthal or a Don Steedman or even a Kim Anderson, but we will get you answers either now or later, so don't be shy. We have 2 hours to spend together, and if you want to hear us drone on in our monotone voices, that is up to you. All I ask is you don't humiliate us up here, because one day it may be you who is sitting up here giving this presentation, and I have a long memory. Let me say that this last year I've had an opportunity to argue I've had an opportunity to argue several cases before the review department and an opportunity to try a case in the hearing department. I've had a busy year, and I can see our practice from both ends just during this last year. As before we start, I think probably the best advice I could give, and primarily I've been a trial attorney, is to know your case, to make your record, to ensure that your evidence, your proof makes it into evidence. It is not enough to just identify your exhibit, but you make sure it gets into the record. And I am guilty of having done that myself. I've made more than my fair share of mistakes. And one thing we're going to be covering today is the notice of disciplinary charges. The review department appears to be taking a special interest in starting their analysis with the notice of disciplinary charges to the extent that it's possible. Make it tight as possible. Of course, we have notice pleading here, but it appears that the review department is taking a very technical view of the notice of disciplinary charges, particularly regarding due process arguments from respondents' counsel. Don't fear.
And the hearing department, Manny, sorry to interrupt. The hearing department as well is taking a very narrow view.
Correct. And it's incumbent upon us to give as much notice as we can. I don't know, some of you who've been here long ago remember that we used to have long form pleadings, and those pleadings, detailed every fact, and when you went to trial, all you did was take your exhibits and cross-reference your exhibit to a particular statement. Now we have notice pleading, but it doesn't appear that a broad type of notice is being accepted. Although, I would argue that personally. But let me say that don't fear making mistakes or stop you from doing what we do. As they say, those who don't make decisions don't make anything, and the work we do here is too important to let that happen. So let me go on to a couple of statistics, not particularly in depth, but over the last year we're talking about a canon of 25 cases. Again, Brandon is responsible for over a third of those, of 9. 4 of those were published. 2 of those were Brandon's. 21 unpublished. We had 2 state bar requests for publication for cases we thought were of such import that we thought they should be published. Those were Brandon's cases as well. In the canon of cases we had, the state bar sought review in 3 of them, or 12%. The respondent sought review in 19 of them, or 76%, and both parties in 3 cases sought review, or 12% again. Out of those 25, the disposition was affirmed 17 times, or 68%. In 1 case, the disposition was higher, or 4%, and in 7 cases, the disposition was lower, including 4 dismissals, and we're going to talk about the dismissals because there seems to be a trend of the review department being much more willing to dismiss a case even after culpability has been found by the hearing department, even after decisions by our office to say that there's a righteous case here. In 4 cases, 16% of the cases they dismissed. And that's not a reflection of our work. Sometimes hard cases need to be tried. That's just the way it is. But then again, it should never be a situation where you walk in there and a good case went south because you didn't know your case. All righty. That having been said, let me get into the sum and substance of what we're talking about here. I've extrapolated 4 kind of lessons, and again, you can accept or reject these lessons as you want. And they're in the outline, but I'll paraphrase them. One is that when you have a situation where an attorney is acting as a trustee in a case or a fiduciary in some other capacity besides a attorney-client relationship, either a conservator or power of attorney, the review department in this past year appeared to give a lot of deference to the respondent's narrative of what his intentions and motivations were when he executed particular actions that we thought were misconduct. The review department also tended to look very closely at the instrument that gave him this power. If it was a conservatorship, they would look at the court order, or if it was a trust, they'd look at the trust document. And they were deferential to the facts and circumstances in there, even when I would argue, the documents were drafted by the respondent. So, there seemed to be an inherent conflict there, but they gave a great deal of deference to it. The second one is that the review department seemed much more willing to reject the hearing department's factual and credibility findings. Flat out, just saying, hey, you said he was more credible, but you didn't tell us why. We're rejecting it. We're moving on. It's contradicted by other evidence. Especially, and they would accept those, even rejecting credibility findings where respondent gave, I would say, implausible explanations for their reasons for their conduct. Their narratives were conjured up after the fact and were used to justify or give a patina of legitimacy to what we considered misconduct when we went forward. In a number of cases, the review department was willing to reduce, as I said before, discipline substantially, or dismiss the case outright. And that happened in 7 cases that it was reduced or dismissed, and of those, at least 5 was substantially. And the last thing I would say is that, and this is a reiteration of something I've already said, that the charging is important. The review department has demonstrated in oral argument specifically. In the Lingwood matter, it was a very hostile review department, and I'm not saying they weren't right, I'm just saying that's the way it was. They looked at the charging instrument as a very technical document and the language therein. So be careful with your charging. Those are the first primary and overarching themes that I see. And remember, you can ask any questions at any time. There were 4 published cases. I'll name them off. They're in the outline. Mpanza, Gonzalez, Gordon, and Lingwood. Lingwood was one that I argued and was not a feather in my cap necessarily, but it's an important case, and I think that it's one of the 2 important cases that we'll be discussing in detail today. And let me just say for this first section here, regarding cases regarding trustees and other acting in either a trust capacity or a non-attorney fiduciary capacity, I'm going to be going through the facts a little more detail than ordinarily because these 2 cases make up a lot of our presentation today. And those cases are going to be Lingwood, which is the published case, and Bradshaw. And those 2 cases touched on a number of issues we're going to be talking today. So let me get into Lingwood. Unless there are any questions or concerns. Respondent, Rita, withdrawn. Let me just state for one thing I forgot to mention. I'm one of those people that always puts on a stopwatch to make sure that I don't go over my time here and bore you too much. Respondent Rita Mae Lingwood sought review of the hearing department's decision finding her culpable of 3 of 4 counts of misconduct, one of which the hearing department dismissed as duplicative, and recommending she be disbarred. The respondent had drafted trust documents for neighbors of hers in the past. One of those neighbors became ill and passed away, and another one became incompetent and had to be institutionalized. Subsequently, she became trustee of the trust that she drafted. During the course of her administration of that trust and as acting as trustee, she sent an email to one of the beneficiaries, and there were 3 beneficiaries, but she only sent the email to one, asking if she could take out a $60,000 loan. The beneficiary, whose mother had just passed away, did not respond to the email immediately, And within 10 days, respondent started withdrawing money from the trust, totaling $60,000 in 2 installments. Because, as the State Bar argued, she had financial problems. She had bankruptcy in her past, she had money problems, and she was kind of manipulative in the email, saying to the beneficiary, hey, you know, I felt a tingling in my hand the other day, and it showed to me that your recently deceased mother basically wanted me to have this money. That was brought out in trial. It was, and the deputy trial counsel who tried the case actually cross-examined the respondent on that pretty well. In sum and substance, the hearing department found that she had misappropriated the money. She didn't have authority to take the money. It wasn't a loan. She didn't follow the prophylactic imperatives of former Rule 3-300, and she made misrepresentations to the beneficiary's subsequent counsel. In sum and substance, upon review, the respondent argued that the hearing department mistakenly found that she misappropriated the money and lied about it, whereas she argued that she loaned herself $60,000 from trust funds without following the requirements of 3-300. The review department found that the respondent had the authority to borrow the funds as the trustee under the terms of the underlying trust agreement, which contained a self-dealing clause, and therefore rejected the hearing department's misappropriation and misrepresentation findings. The funny thing about the self-dealing clause was that it wasn't until they were halfway through trial that even the respondent realized that there was a self-dealing clause she had placed into the trust documents. So it was her counsel that basically read the document and did his job and brought this issue and brought this defense. And that became the defense that she used, she ended up with. It wasn't really one that she started out with, but the one she ended up with. Based on that and relying on the trust documents, the review department stated that she had the authority to do it, and there was not a opposing evidence to that fact presented with trial. There was no expert witness or anything saying no, she didn't have the authority to do that, and mostly because there was no anticipation that defense was actually being raised. Quite frankly, it was raised halfway through trial. But although the review department reversed the misappropriation and the misrepresentation charges, it did confirm the 3-300 violation, mostly because respondent admitted to it in all of her pleadings, and it did revive the 6068A violation, which the hearing department had dismissed as duplicative. This case does have some good for us, and that is it reiterated that which we already knew. First of all, can an attorney be disciplined for misconduct committed while acting as a trustee, not as an attorney? Who thinks that they can? Well, thank you, Rachel and Susan Kagan. Yes, the answer is yes. I know we're all it's a little early in the morning, but yes, the answer is yes, and the review department has held that in the past. And the Lingwood decision reiterated that rule. Even though a non-attorney can serve as a trustee, an attorney trustee who is also performing legal services in a dual capacity must conform all the services performed to the rules of professional conduct, and the decision cited Layton versus State Bar. They go on to say that an attorney entering into a business transaction arising from her duties as a trustee is not exempted from Rule 3-300. And lastly, beneficiaries of a trust, and this is an interesting one. I mean, this is also an issue that has been dealt with before, but the beneficiaries are not her clients. You know, the clients, she has an obligation to execute the trust in accordance with the probate code, and her clients really were the settlers of the trust, who one was passed away and one was now incapacitated. But as we all know, duties can arise from third parties, and the case we always, I can't remember the name of it, but it's where one person walks in and he has an industrial accident, and the attorney didn't tell the wife, hey, you also have I don't want to say conjugal visits. What is the consortium claim? That's the one we use in ethics court in the ethics school. But in this case, the court said the beneficiaries of a trust are not clients of an attorney trustee, but the trustee may nonetheless be disciplined as if they were the clients because of the attorney's fiduciary relationship with the beneficiaries. They're not clients, but they're the fiduciary relationship created by that relationship. That, yes, sir.
Clarify. Normally it'd be the settler that would be the
Client.
But because the settler was incapacitated, then it goes to the beneficiaries. Is what they said.
Correct. Well, that's correct.
Can you repeat that for LA?
The question, or actually the statement, or the correction was that, and this was by Alan Blumenthal, who, you should be up here, Alan. He stated that, to clarify, that ordinarily it would be the settler who was the client, but in this case, one of the settlers had passed away and another one was incapacitated, and therefore that duty, that fiduciary duty, passed on to the beneficiaries, if that's what you said. And that is correct.
And can I interrupt
Alrighty,
for a
here.
second? There's case
Yes, ma'am.
law on page 8 of the decision that actually discusses that, the authority for that position if you need it, so.
Correct. The second matter that I'm going to discuss under this particular topic is Bradshaw, and Bradshaw has a long and illustrious history for those of you who are new to the office, with this office. And I'm going to go into the facts a little bit here because I think they're important. Bradshaw had been hired by a lady by the name of Gosi, Ora Gosi, to create trust documents and do estate planning. Years later, that was in 2007, years later, she had suffered an accident. She fell in her apartment and she was hospitalized for a while. And she was, during her hospitalization, they found that she was incompetent, basically, through dementia, to handle her own affairs. The trust documents had named other people to take over as trustee, but those people either declined or didn't serve. And respondent was asked to take over as a conservator. Application for temporary and permanent conservatorship was filed with the court over the estate and the person, and he was ultimately appointed. There was an estate, her house was worth like $1.6 million. It was here in San Francisco, and she had an estate of about $2 million, I guess, or thereabouts. Respondent, acting as the conservator and in a fiduciary capacity, there's two versions of this story, one of which the review department tells and one of which we told, and I'll tell it as the review department told it, but our theory was a little different. Respondent helped a gentleman who was an unsophisticated, non-native English speaker immigrant who didn't have a contractor's license to set up a Bay Construction. Bay Construction was a construction company that respondent provided the capital for, provided the credit cards for, handled all the finances for, and respondent used Bay Capital or Bay Construction to effect repairs on Ms. Gosi's house, fixing stairs and plumbing and other things, thereby taking trust assets and placing them into Bay Construction. Our theory of the case was that this was a scheme to defraud, and I think the evidence can be argued either way, and I think we had the correct argument, but I'm not going to, excuse me while I go past my 10 minutes here. Alrighty. A scheme to defraud, to funnel money from Ms. Gosi's trust into Bay Construction as a pass-through to him to pay for either legal fees and also because he was in fact the owner of the company. That is our theory. I think it is a good theory. It was rejected by the review department, and I'm not saying they're wrong, but you know they're wrong. I know, Kevin. I'm not. The point is that the review department accepted kind of the self-serving narrative of the respondent. There were these documents that he prepared that showed that this unsophisticated man was the owner of this company. that he didn't possess a contractor's license, but they had gone out and found an out-of-state contractor to oversee the work, despite the fact that they didn't actually oversee the work. And they accepted that and they dismissed the case. The reason these two cases are important is because it shows that the review department is going to look at the evidence and the documentation within the trust. They're going to look at the trust and the spirit of the trust, and they're also going to accept the respondent's narrative of their intentions when they were acting in a fiduciary capacity. And I think this has had a direct result on our practice before the hearing department. I recently tried, this has not been a successful year for me, by the way. Let me just say, I tried the Andrews matter, and it involved an attorney who represented the trustee, who was her mother of somebody who had Alzheimer's dementia. And that decision came out after these two cases, and the hearing department dismissed the entire matter. So the review department's findings have a result on what we do, but also it educates the hearing department, and they will act accordingly. Are there any questions or concerns or anything that I did not cover that should be covered in more depth?
I'll throw out one thing.
Yes, sir.
With regard to Bradshaw and the other case, and there's a lot of different ways that one can look at that case because those two cases, because there's so many moving parts to them. But on the issue of scheme to defraud, I think it's always worthwhile for us as prosecutors when we're initiating such a charge, not to think just about what we believe the definition of fraud is, but always think about what is the court's definition. And I'm not certain that our view of what the definition of fraud is the same as the review department's. And I'll give you an example without taking up too much of your time, Manny. We see this, and I'm seeing this a lot in the conviction matters currently. A violation of a tax code, whether it be the IRC or the state code, involving the attempt or the actual evasion of taxes, I think many of us here, myself included, would find a reasonable argument that that's an intent to defraud. And in fact, there are cases that say that. However, our review department has not gone that far. It will not take that step. Now, you do have false filings and fraudulent findings, and there's not an issue there. But when it comes to an attempt to conceal an asset in the tax setting, an attempt to evade taxes, the review department has said essentially that is not per se fraud. And it's a different view. And I can't tell you, maybe there are others here that can give us more insight than I can, how to define or how to describe what the review department's definition of fraud is. But there's a disconnect between the court and our office right now, which I think is worthy of a little bit of consideration.
Let me summarize that just because I don't know if everybody heard it, and I hope, and if I don't summarize you
We
correctly.
heard it, Manny.
Yeah, I was hoping I was speaking loudly enough.
What's that?
We heard it.
They heard it? Okay. Okay, good. I do actually want to mention one other thing, in that the review department has found in cases where an attorney is acting as a trustee, has found them culpable and disbarred. And I'm thinking about the Schooler case, which was decided back in 2016, and I believe this was argued by Mr. Alan Blumenthal. And this case, I think, is distinguished from the ones that I just presented by the fact that there was actually an underlying superior court or probate court finding that the respondent had engaged in misconduct, and an order that came out stating that. In these two cases, there was not such an order, and I think that had we had one, the situation could have been different. Do you have anything to add to that?
Well, it's obviously a lot easier if you have an order of the court saying that. And by the way, Kim Anderson tried that case.
And Anand Kumar was my co-counsel.
And so, yes, it's helpful, but there's a lot of reasons why we might not get such an order. One is the fiduciaries may not have the financial ability to hire lawyers to do it. Two, trusts and wills often have if you sue, you lose your inheritance clauses. So it's nice if you get it, but it's impossible to expect that that's going to be the case in every case that you have to go to trial on.
Did you hear that, or do I have to repeat it?
We heard it.
We got it.
Perfect. All right, with that, I'm going to turn it over to somebody more articulate than myself, Mr. Hackert. It's your show, my friend.
All right, thank you.
You got
So the next.
putting the timer on you now, too.
Oh, good, thank you. Much of what Manny was talking about regarding overall the issues we've been having with these sort of probate trust conservatorship cases also relates to the misrepresentations that we've charged within those cases. And again, we have Lingwood and Bradshaw in the outline, and I won't go too far into the weeds of the facts of that. Manny already did a good job of giving you the big picture, and we basically have to read from the opinions verbatim to sort of get the full flavor of the specifics. But overall, the big picture for these types of charges is it's looking like these violations are not as easy to prove as we'd like to think they are, especially since the court has been giving a lot of deference to respondents' statements and versions of events. On that point, I would pull out a real quick example from Lingwood. The loan that she had taken out from the trust, she basically was using it for personal expenses, despite that it was the loan was secured against a note on her condominium. So in describing that to the beneficiary, well, she said, well, I don't consider this to be a personal loan, and the beneficiary was saying, I don't want you taking any money out of the trust for your own personal use. But she said, well, it's not a personal loan because it's secured, and I think a personal loan means unsecured loan. And so the court bought into to her statement, despite that she was really just using that money to alleviate her financial distress. So the court went with her on that one. So basically some things to think about in looking at these types of charges is look at your alleged misrepresentation, and then you need to consider why is this objectively false or misleading, and importantly in the context of misrepresentation being made to either a court or some other tribunal, why is that misrepresentation material to the issue and the context in which the misrepresentation is made. And an example from Bradshaw is early on in the case when I believe he was trying to get appointed as Ms. Gosey's conservator. In his declaration, he had mentioned that Ms. Gosey was taken out of her home by San Francisco Adult Protective Services. That was not factually true. The actual sequence of events was APS came to her house, and then later her tenants had her taken to the hospital via ambulance. And the review department said that's not really that material to the issue of why she was taken out of the home. It was sort of, overall her health was why she was taken out. Even though we made the argument that respondent was trying to cast these facts in a light that was most helpful to get him appointed as conservator in order for him to further, get going with his scheme regarding the construction company. The review department rejected those arguments and said, there's other facts in the record that support respondent's appointment as conservator, so that's not really a material misrepresentation. So that's an important point to think about in your cases. And then, of course, why is the misrepresentation made? Why is that being made intentional or grossly negligent? One of the misrepresentations in Lingwood about the nature of the loan that Ms. Lingwood took regarding her condo is the court noted that she, despite her characterizing the loan as something that we said it wasn't really, she didn't really hide the facts as to what she did, and so the court found that she was very open about, despite her mischaracterizations, she provided the documents showing that the loan had been recorded against the condo and all that sort of stuff. So the beneficiary was effectively aware of the real operative facts underlying her statements, so they didn't find that to be a misappropriation. Somewhat similarly in Bradshaw, the court sort of, you can all, from our perspective, say split hairs on some of his pleadings, and he had hired a probate law expert to talk about, well, under the probate code, the layperson, or these statements are technically correct, even though a layperson might say that, they're somewhat misleading. For instance, he was talking about having a financial interest versus a financial relationship with the construction company, because one of those is actually a term of art under the probate code. So the court gave deference to respondent's explanation in that matter. Conversely, if you flip the page over, where there's some pretty clear-cut misrepresentations that the court was willing to find is in the matter of Gordon, and Kim's going to talk about that case later, and it's pretty unique, and she'll get into some more of the facts and why it was published. But basically, it was a massive loan mod mill. The court found that what respondent was doing in order to get clients, he was basically in part of his marketing materials, or you have these bank of phone operators in this like boiler room type of operation. They would tell these prospective clients that, oh yeah, you're going to have a lawyer who's going to be working on your case. And Gordon was the only one there in this operation who was an attorney, and it was non-attorney staff who were working on these loan modification applications. Also, not in your outline, there's a bunch of advertising violations found that relate to this. Gordon would frequently change the name of his company and change his website to sort of stay one step ahead of Better Business Bureau complaints. He would reuse the same client testimony from the first website, put that on the second website, and attribute that to the new company. His websites didn't identify himself as the attorney responsible for the advertisement. Also, when these non-attorneys were in contact with the clients and trying to sign them up, they'd sort of allude to there was affiliation between them and HUD. And they'd also, part of their advertisement is they would sell these people, quote unquote, custom legal products when it was just a loan mod mill. And they were just, going through a standard script as to how they were contacting the client's banks and that sort of thing. So, you have this contrast between Gordon, where you have these pretty clear-cut issues in the context of a loan modification versus the other misrepresentations that we've been having a lot harder time with. So, we haven't been totally striking out on misrepresentation issues, but again, we've been having a hard time with them in respect to the trust and state cases. So any questions on that topic?
All right, I guess I'll finish up that topic just for a minute, and then I'm going to move on to misappropriations. The fiduciary cases are extremely difficult. And I think the takeaways for our office in terms of investigating, charging, and trying these cases is we may need one or more experts or consultants in various areas relating to the fiduciary duty itself, and also relating to other issues like, for example, in Bradshaw, the value of property or the value of services. So you have to look really carefully at the facts. And cases without civil findings need to be evaluated carefully. I don't think the answer is that we avoid charging these serious cases just because there aren't civil findings, because as Alan Blumenthal mentioned, sometimes the complaining witnesses may not have the money to pursue a civil lawsuit. The other thing about both the fiduciary duty breaches and the misrepresentations is if there's any plausible explanation for the respondent's action, we lose. And sometimes plausible may stretch into things that seem less than entirely plausible to us. But in evaluating these cases, we need to look objectively at how is somebody else going to see the respondent's story, and how can we close every hole so that the respondent's story is not seen as plausible. And I don't know the answers to those things. Now, talking about misappropriation. Oh,
If I could interject one thing, and that is, yes, if we can have an expert, that's great, but it doesn't mean you're going to win. We had an expert, a great expert actually, in Anderson, not Anderson, Andrews, but they had 3 experts, and so don't think that an expert is going to save the case, but I agree with Kim that if you have those questions, those close calls, and you're going to need somebody to explain it to the court. Thank you, Kim. I'm sorry.
sure. And there are 2 cases up on review now, so we'll talk about them next year. One is the Elaine Andrews case that Manny mentioned, and the other one is the Renee Lilly Campbell case, which I tried, and Alex Hackard has the pleasure of now handling on appeal. So those cases are coming. In misappropriation land, in your outline we have Lingwood and Bradshaw. I'm not going to spend a lot of time on that because we've talked about that in some detail, other than to point out that when you try to charge misappropriation in a context that the court is not familiar with. The court, in a more abstract way, the court may not understand that it's a misappropriation. So, for example, our court gets that it's a misappropriation when an attorney is holding money in a trust account for a client or a third party, and then that money or a portion of that money is taken out of the trust account. They get that, but when you have a case that's a little more subtle or abstract, where the attorney's taking money from some other account or some other way, they tend to be reluctant to call it a misappropriation. So just think about that in terms of your charging decisions. Is it really a misappropriation? Maybe it's a misappropriation and a conversion, or maybe it's simply a breach of fiduciary duty. They took the money and they breached fiduciary duty. Scheme to defraud, I think, is hard to prove because then the court looks at, did you prove every element of the fraud, and is there some explanation that's plausible as to any of those elements? So it becomes a harder case than maybe charging insular 6106 violations, in my opinion. And I think very intelligent people may differ on that and say, well, we should charge it that way. But those are my thoughts on that area. There are some misappropriation cases that are very interesting that we're going to talk about. Lisa Mackey, an unpublished decision, but I'm going to save that for later. We'll talk about that in the potpourri section. And then I think the Haddon case, which Manny's going to talk about also, is an interesting case. And with that, I'll turn it over to Alex, who's going to talk about Rule 9.20.
All right, so especially for the newer attorneys who often get these matters, definitely listen up here, and I would encourage you to read both of these decisions, especially on FONSA, because that one has been published. You know, traditionally with the 9.20 analysis, we're often, you know, we start with Berkovich v. State Bar, which is a Supreme Court decision, which basically says a willful violation of the rule is a serious ethical violation that does mandate disbarment per the terms of the rule. The exceptions to those matters, or where discipline less than disbarment has been warranted, is traditionally, and I might be butchering this a little bit, is where you have perhaps attempts to comply with the rule, or substantial mitigation or minimal aggravation, some combination thereof, and that's what we have in FONSA, where we have a respondent who, after receiving a 90-day actual suspension for CTA-related violations, did make some efforts to notify his clients about his suspension, but those efforts were not in compliance with Rule 9.20a, and he also failed to notify opposing counsel and the court in matters which were his litigation cases, and then was unsuccessful in filing a 9.20c declaration. Also, this respondent was able to avoid disbarment because he presented successfully his evidence regarding extreme emotional difficulties, which in my view, I think the court has been a lot more strict in evaluating respondents' evidence regarding these issues, making sure that respondents hit all of the elements under the standard. And we can talk about a case, well, actually the next case, Lee, was a spectacular failure by the respondent to do that. But FONSA was successful about that in presenting that. And the court basically concluded that, you know, respondent was making efforts to comply with Rule 9.20. He didn't do it the right way. He was under, you know, experiencing severe emotional difficulties, severe depression. He presented evidence he actually recovered from that and got substantial mitigating credit under the standard. And the court concluded that his misconduct was not indicative of an inability to conform to his ethical norms. So I think that phrase is what's going to hinge on whether or not you have, that's going to determine whether or not you have a disbarment case or an actual suspension case. And also another interesting point that I think to pull out of FONSA is, and this is very brief, and I don't recall a lot of discussion on this, but when I was reading this, if you look at on page 10 of and 11 of the decision, there's a discussion about cooperation with the state bar for the stipulation he entered into, and oftentimes our office will argue that easily provable facts aren't worth a lot of mitigating credit, and you know, 9.20 violation, probation condition violations are generally viewed as that because, you know, there's nothing really for the respondent to dispute. Here's your Supreme Court discipline order, here's the probation file, you either did or did not comply with those conditions. But in this case, the court concluded, Well, he stipulated to these facts. These facts established his culpability. That's worth substantial mitigation. So I think that's something to be aware of, because I think savvy respondents counsels are going to find that language in Infonsa and use it to their client's advantage. So be aware of that. But there are ways to sort of defeat that. And Lee is actually a good example of the exact opposite of what happened in Alfonso, and that was an unpublished decision. And again, credit to Brandon Tatey, because these were both of his cases. But Lee was a little bit different. He was one of those ostrich respondents where he basically he was an out-of-state attorney, but nonetheless he ignored all the communications from the Office of Probation about his discipline order for about 3 months. So by the time he got around to filing his declaration or attempting to come into compliance, it was very long afterwards. He had really no excuses for it. He did try and raise issues regarding some mental health problems, but when he actually presented we stipulated to allowing him to present telephonic testimony from his out-of-state psychotherapist. But the therapist said, well, I still need him to come in and see me, and I've recommended that he get evaluated by a medical doctor to see if depression medication would be helpful for him. So the court was very critical of that and said, he could still be a threat to the public, because if he's saying, well, I can't comply with my, my 9.20 requirements because of these issues, and you haven't resolved them yet, so there's still a problem there. And while Mr. Lee also entered into a similar stipulation that we had present in Alfonso, the court determined that mitigating factor was undercut by Mr. Lee raising a meritless defense about willfulness in the context of 9.20 violation, arguing that a criminal standard regarding sex offender registration should apply to Rule 9.20 proceedings, and the court rejected that argument and found that we argued that demonstrated respondent's indifference to his 9.20 obligations, but the court said, well, instead we're going to use that and undercut his mitigation by raising this meritless defense. And was also significant, a takeaway between these two cases is that the analysis is a little short on this point in Lee, but it is important. Lee's underlying discipline was he was representing it was a severe case of client abandonment that basically resulted in his teacher client losing one of her credentials for one of the states that she was accredited in. And Judge Stovitz, who wrote the opinion, sort of seemed to view respondents, these misconducts, the 9.20 violation in the underlying case is very similar, and the totality of that is indicating that he's basically just sort of thrown his hands up in there in regards to his ethical obligations. So, if you have a 9.20 case, you can definitely glean a lot from these two recent decisions and get an idea of how the court thinks about this. Also, too, an important takeaway from Alfonso, if you have this pop up in your case, the court was very critical of the language that the Office of Probation has been using in their non-compliance letters that they've been sending out to respondents. How to fix that problem is beyond the scope of this presentation, but it is something to be aware of, because the court looked at that and was of the opinion that if you keep telling a respondent that you can't be fully compliant because your deadline to comply with your probation conditions or your 9.20 is passed, then it gives the impression on the respondent that their efforts to rectify that could be futile, because then they're never fully compliant, to use a terminology that probation uses, which is technically correct. But nonetheless, the court doesn't seem to like it. So they use that to undercut our arguments that respondent demonstrated indifference and didn't give us that factor in aggravation. So there's a lot to go in there, and like I said, definitely read Alfonso, and then check out Lee as well. And then we have another similar case that's up on review that I expect respondent will get disbarred, because he's advancing similar arguments to Lee. So I have a feeling that we'll get good results on that case. So. All right.
I have a question up here from Susan Kagan.
Sure.
Sorry, I believe the Office of Probation has changed the language in those letters. Is that
Yes.
correct? So we shouldn't be facing that issue again.
So the Office of Probation has apparently changed the language in their letters, and we probably will not be facing that issue again.
We do need to be careful as to cases that may have the old language.
Right.
So you still got to take a look for that.
Yeah.
But presumably that will eventually disappear.
Unless, of course, the new letter has problems that we don't know about.
That will be different problems. Deal with that.
Yes, sir. All righty, it's my turn
Oh,
again, and I'm going to
can
talk
I-
about a
wait,
case.
Manny,
Oh,
can I interject?
go ahead.
One thing about Consa also. I think that one of the things to think about when you're doing a 920 case is a lot of times we charge only the 920C violation for not filing the declaration on time, but if you have evidence in your case that the respondent violated A, we should consider also charging the A violation. You may get more bang for your buck in terms of culpability and discipline. All right, I'm done.
Perfect. I'm going to talk about Lieb, a case that was tried actually by the Right Honorable Ms. Maria Oropesa and duly assisted by Ms. Laura Huggins. It's an unpublished decision. It is a review department decision in which the conclusions are not particularly noteworthy, but the facts are very interesting. Mr. Lieb was an attorney back in the 1970s for a very brief time. Mr. Lieb, prior to him becoming an attorney, had befriended a fellow student at UCLA, and this fellow student's family had taken a liking to Mr. Lieb and treated him very well. Mr. Lieb, who was in his 20s, dated their 16-year-old daughter. The father gave him an apartment to live in for free, so all he had to do was manage the building. He also gave him another job. They went to religious services together. They were part of the same religious type community, and had him over for dinner at their house. All of this generosity did not prevent Mr. Lieb from stalking, chasing down, and murdering this friend of his. After he was arrested for murder and placed in jail, Mr. Lieb was still an attorney because he hadn't resigned immediately, which you would think would be one of the first things I would do. No, he waited. He actually litigated his bar license all the way up and through his conviction and sentencing. The respondent, the petitioner, served over 26 years in prison. At the beginning of his sentence, he was no less violent than he was when he got arrested. He had been involved in fistfights and other violence. There was a finding, although it was later reversed, that he had actually taken part in a prison murder, although that was later rejected by the prison authorities and the courts. And in his own testimony before the probation board, he came up to the parole board many times. One of them, he said, I'm not involving myself in the prison programming, that is to say the rehabilitation and other programs they have there, particularly the ones that involve like blue collar work, that's just not me. At some point, he saw the light and realized he wasn't going to get out of prison unless he did participate in these programs. So he did that for a long time. He was eventually released on parole. He spent time on parole. He was released from parole, and almost immediately, within a year or thereabouts, he applied for reinstatement to the state bar. Now, it is almost axiomatic, I should say it is axiomatic, that somebody who is looking to be reinstated to the practice of law has to demonstrate by his rehabilitation over a sustained period of time through exemplary conduct. By the time that he actually applied for reinstatement, he'd only been out of supervised relief for a little over a year. And his argument was, when he sought review of the hearing department's rejection of his application, was, you should not only count the time that I was on unsupervised release, but you should count the time that I was on parole and in prison. And he cited, for that proposition, kind of an outlier case, matter of Bodell. Matter of Bodell was a case that involved an attorney who had been convicted of one count of felony mail fraud. And in finding that Bodell had established his rehabilitation, the court considered the 10 years following conviction and did not exclusively focus on his post-probation conduct. That is to say, they took a look at some of his conduct while he was on probation. And although they didn't give great weight to it, and I think that's pretty much what they stated in the opinion, they took it into consideration. Well, respondent in this case, who was convicted of first-degree murder, said, Bodell supports his proposition that you should take all of my conduct from while I was in prison, on parole, and subsequent to that into consideration when making the determination of whether or not I've rehabilitated myself. Of course, the problem with being in prison and on parole is that you are supervised and expected to do well. And the consequences for not doing well are, one, if you're in prison, you don't get out of prison. And two, if you're on parole, you might go back to prison. So the incentives to do well are there. The review department, of course, rejected his argument, and this is one of those cases that you know you're going to win almost from the get-go. And those are the worst cases because if you lose, for God's sakes, you know you're really you're really in trouble. But it was an interesting case, and let me just say that the record here was very good. When you get a pit bull like Maria on this case, no fact will be left unturned. They rejected some of our arguments. Maria had argued that his helping other prisoners with their habeas petitions was actually the unauthorized practice of law, and therefore he should be rejected for that basis. And she argued that right up until the decision came out that we should be arguing that. But the review department basically stated that, and this is what the takeaway is, if there's one that wasn't already baked into the case when it began, which in differentiating Bodell's analysis, the review department stated that Lieb's misconduct is extremely egregious. And the reason that they're not following Bodell, but instead are following the dictates of other reinstatement cases, Gossage and Mena, and that they applied because of the gravity of the underlying misconduct. And so much less weight was to be given to him for the conduct that he did in prison on parole. It was a fascinating case, just factually, having to go through these thousands of pages of documents. I don't get personally invested in my cases, quite frankly, almost ever. But there was one, his older brother, and his older brother would testify at these parole hearings. And his older brother would face this man who he thought was very dangerous. And he gave one speech about his murdered brother that was so moving that I actually included it in the brief. It was a fun case to do. The obvious result, it was a good result, and the result that it was almost preordained. The trial attorneys did a great job. So moving on.
All right, I'm going to talk about any questions on that subject before I move on. I'm going to talk about in the matter of Gordon, which was Alan Blumenthal's case on review, and this was quite an interesting case. I'm going to talk about it primarily in the context of improper partnerships and sharing of legal fees. As Alex mentioned, there were some false advertising claims in this case leading up to the attorney basically running a boiler room for Loan Mod and signing up clients with a false impression that there was a lawyer running the show, when in fact there wasn't a lawyer running the show. And I think this case was published because we don't have a lot of these cases. We don't have a lot of advertising cases. And while we do have a handful of Loan Mod cases now, Loan Mod really isn't the big issue in this case. It's the partnership with the non-attorney and the fee splitting. And the other unusual aspect to this case, I'll just mention for anybody who's not familiar with it, is Mr. Gordon was extremely abusive to the staff of our office. And the review department, I think, wanted to discuss that as well. He made threats, real serious threats to our office. And I think there's only one other case I know about in recent review department history involving that, and that was a case Jane Kim and I handled. There was a mini reinstatement involving Bradford Henschel a few years ago, and I think they discussed his abuse toward state bar staff. So I just mentioned that if you need a case that talks about abuse toward state bar staff. And in the matter of Gordon, one of the findings, as I mentioned, was forming a partnership with a non-lawyer. And the facts that led to that were the attorney operated a common enterprise with a non-attorney, and he commingled finances. They used common facilities. They shared employees. They shared physical resources, like office resources. They acted with the common and singular purpose to unlawfully obtain advanced attorney fees from clients to provide loan modification services. And the respondent raised several defenses to that, all of which the review department rejected. He argued that the non-attorneys were not engaged in the practice of law because they merely performed ministerial acts relating to marketing and sales of respondents' service. He argued that the loan modification services by the non-attorneys is permissible in California, so that such conduct does not constitute the practice of law. And he argued that the respondent's business was separate and distinct from the non-attorney's business. Essentially, the non-attorney was supervising the employees, and he was paying to borrow the employees, essentially. The review department held that even if the services were not considered legal services, where clients hire an attorney to perform services that may be done by lay people, they do so because they expect and are entitled to legal counsel. The review department also concluded that the parties did have a partnership, and cited to a case that I tried and Brandon Tatey argued on review some years ago in the matter of Jack Wang for that proposition. So that was discussed, I think, probably 2 or 3 years ago at the current developments review department. The second finding that they made related to this issue of unauthorized practice of law involved sharing fees with a non-lawyer, and where the attorney formed a partnership with a non-attorney and they agreed to share revenue from the legal services that were marketed by the non-attorney and attorney sales and the non-attorney sales staff, 1/3 to the attorney and 2/3 to the non-attorney to pay himself and the sales commissions. The attorney was culpable of sharing fees with a non-lawyer. And I don't think there are a lot of published fee-sharing cases out there. Anyone have any questions or comments, including Mr. Blumenthal?
Well, yeah, one is Eli tried this, so we should give him credit. He did a nice job trying this case. The other thing, the
Stand
couple
up, take a
things
bow.
on the partnership, what's really interesting is, they continue to use the general law of partnership. So they will apply the law of partnership to whether an attorney and an employer have a partnership, and they will use more of this adult look, things like, are you sharing offices? Do you have a common goal? Are you sharing fees as a factor? All of these things. So it's a really good case for that. On the fee sharing, the other interesting thing is they found not just that he shared fees with his partner, but that he was doing it with his sales forces indirectly. So it shows you can actually get that violation when there's an indirect sharing, which is consistent with the statute and the law. So I thought those were really good points.
Thank you, Mr. Blumenthal.
I think that
Oh, Manny?
there was a case up here, Deutsch, I don't know, had it gone to trial, had presented similar issues. She was known as the tax lady up here. She was eventually disbarred. I think she defaulted on one of the charges. There were hundreds of cases, but we only went to trial on 1 or 2 of them, as I recall.
Well, we never went to trial.
Well, we were pursuing 1 or 2 to go to trial. I think Don Stephen handled much of that. And in fact, Robin Brune handled it. I know that Carla Chung had some involvement in that as well. But this is an interesting case, and it's good that it's out there. All righty, let's move on.
Now we're on potpourri, right? And I get the first potpourri case? Mr. Barr?
Let me just say that just as a side note and as a, the reason I named this section potpourri for $100 was because this is embarrassing. I was listening to Weird Al Yankovic sing "I Lost on Jeopardy," and that stuck in my mind, and that's why it's here. So, all righty, go ahead. I'm sorry, Kim.
All right, so Mr. Barwaj lost too. It was a really interesting unpublished case. Mr. Barwaj was representing himself in his own divorce proceedings, and he was a vexatious litigant who bullied his ex-wife. And one of the more interesting things, I couldn't figure out why this happened, but he actually went to trial on the issue of spousal support. And he had lost his job as an attorney, and he sat through a 3-day trial and let everybody think he was making $100 and something thousand a year, including his ex-wife and the judge. And then when the judge issued the order, he went in and tried to get it reconsidered on the grounds that he was no longer earning the money. So the court didn't like that, and his behavior was equally irrational on appeal. He did things where he tried to file appellate briefs in the underlying divorce case and get around the page limit by coming up with extremely unique abbreviations, not the standard abbreviations that lawyers use in their briefs. And unfortunately, I can't come up with examples, but probably Kevin Taylor has one or two. I think he did this case on review. The interesting thing about Barwaj to keep in mind, or one of the interesting things, is that we tried to charge 6068A based upon the page count issue, that he didn't comply with the local rule of court. And we also tried to charge a 6106 moral turpitude based upon his abuse of the page limit, which was so extreme. And the court did not find either the 6068A or the 6106. The court said that moral turpitude is something that shows a deficiency in any character trait necessary for the practice of law, such as trustworthiness, honesty, fairness, candor, or fidelity to fiduciary duties. It involves such a serious breach of duty owed to another or society, or such flagrant disrespect for the law or societal norms. So what it said is, while abbreviations are in this case, while Barwaj exceeded all bounds of normal abbreviating to accomplish his improper goal of falling below the word count, that didn't amount to really a moral turpitude. Lots of attorneys use abbreviations, and it's common and often appropriate in legal writing. But what they did say in the case that's really interesting is, even though it didn't rise to a culpability violation of moral turpitude or 6068A, it could be used as an aggravating factor in bad faith. And so the court, so if you look at the Barwaj decision, it's kind of long, but read pages 11 and 12 and 21 if you're looking for an example of where we got findings of bad faith for things that we weren't able to prove up as actual violations. And that's all I've got to say about that, unless there's any questions. And let's see, the next one I think is Alex.
Mr. Gonzalez, this is actually a published case. There's a couple little good nuggets that we can pull out and use out of this guy. Mr. Gonzalez, this was his third disciplinary matter. He'd been involved in the disciplinary system since around 2011. This is a case where he's found culpable of a 9.20 violation, failing to cooperate, engaging in UPL, acts of moral turpitude, and collecting fees while fee-related violations. All his prior misconduct pretty much involved more or less the same fact pattern. He was a criminal defense and immigration law attorney. He committed misconduct in relation to his clients, basically performance and other types of related violations, what you would kind of expect to see. Ended up initially with I believe a 60-day actual suspension, then he picked up a year suspension. In this case, the court decided they'd had enough of him and decided that it would be a good idea to disbar him. The first point is that we have a finding under standard 1.5N for highly vulnerable victims, and this is a really good finding for us, and you can definitely use it in your cases. We had this argument rejected at hearing, but the review department found that his clients were all 5 highly vulnerable victims. In this case, they're all immigration and criminal clients, and they assigned significant aggravation to that factor. One of the clients was an incarcerated criminal defendant and was vulnerable per se because he was limited in his freedom to assist respondent or stay apprised of respondent's efforts in his case. The other 4 clients were highly vulnerable because they were immigration clients and their cases could result in their deportation. So, obviously you want to flesh out the vulnerability factor beyond just the sort of per se analysis to, really give life to your case, but that's a really great finding for our office. We should be able to use pretty regularly. This case also has a really great 1.8B analysis. The hearing judge rejected our argument for disbarment and instead gave him a 2-year actual. The court took a look at 1.8B and said this guy is the perfect candidate for disbarment under 1.8B. He has 2 priors with actual suspension, and the totality of misconduct, it's clear that he's demonstrated an unwillingness or inability to conform to his ethical responsibilities. So if you have a case that involves 1.8B, here's a great recent citation that should be very persuasive if you have even relatively similar fact patterns. So this is a great case for our office.
Alrighty, questions, concerns? And then it's my turn. I'm going to talk about it in the matter of Haddon, which is another case where, from my uneducated perspective, it was a slam dunk, but it was interesting anyway. Mr. Haddon had been hired by somebody to litigate a wage claim before the California Labor Commission. Instead of doing that, he dismissed it without telling his client and filed a lawsuit without telling his client and settled the case without telling his client for $50,000. He was found culpable of the hearing department for various charges, including moral turpitude for misrepresentations of the state bar, fabricating documents, providing false accounting, fabricating his client's signature, and misappropriating client funds, among other things. And the way he misappropriated client funds was he eventually told his client that he had settled the case, but he didn't say he settled for $50,000. He said he settled it for $40,000, and he was making payments to the client less than he was owed. Strangely, on review, the respondent did not contest the culpability findings, which makes this an easy case to go forward on. What he did was he conjured up 3 due process arguments, and they were pretty creative, I have to say. He said that because the OCTC contacted law enforcement and said there might be a criminal case here, but didn't inform him of that, he was divested of his ability to invoke his Fifth Amendment privilege against self-incrimination. The review department rejected that, stating they have an obligation, OCT has an obligation to do such if they believe it's criminal conduct, and they have no obligation to tell you anything. His second due process claim was basically that he was forced to go to a settlement conference without his attorney, and that he was forced to go to trial even though he filed a motion for continuance. The review department basically stated that he did not establish prejudice, that he has the duty to establish prejudice. He failed to do so and therefore dismissed that due process argument. And in rejecting the respondent's contention that he was denied due process because the court did not offer him the opportunity to participate in ADP, the review department held that the hearing judge was not required to make such an offer. And in any event, the respondent was ineligible to participate in ADP because of the moral turpitude findings, dishonesty that caused significant harm to his client. So the due process was the angle on that. He lost on that. There's a lot of case law about due process. That was a foregone conclusion, but it was an interesting case. Questions, concerns before we moved on to Ms. Anderson?
All right, I'm going to talk about Kalik and then Mackey. In the matter of Kalik is an unpublished case. It's an important case, and Rachel Grunberg and Jonna Sack handled it at trial, and they made a really good record. And Kevin Taylor handled it on appeal, and he did a really good job too. This is a good case for our office. Anytime you have a domestic violence case, I believe you should take a look at this case, read the hearing department decision, and read the review department decision, because they took the same facts and came up with two different results. In the hearing department, Judge Armendariz wrote a really detailed decision as to why Mr. Kalik should be disbarred for a misdemeanor domestic violence conviction. In this case, he had 3 incidents of domestic violence, including the one where he assaulted his girlfriend. In this case, he actually bloodied her face, gave her black eyes, and he also lied in the course of this. So it wasn't just a physical violence case. There were lies involved. He lied to the probation officer about the fact that he had prior incidents of domestic violence. And he also lied and created what he called a prank, which was a rather disturbing ruse. And it really, in domestic violence parlance, would be trying to control the victim. What happened was she had applied for a job with a company, and Mr. Kalik decided to impersonate the CEO of that company where she was applying for a job, and made up a phone call from the company as if he were the CEO, and was flirting with her to see if she would flirt back. And so this harmed her in terms of her job, as well as the physical injuries and reputation. He called it a prank. We had a domestic violence expert at trial. I think her name was Nancy Lemon. And she talked about what these things mean in the context of domestic violence. The review department didn't see it the same way. They didn't think that this needed to be a disbarment case. And Judges McGill and Hahn still thought it was a serious case. They acknowledged that domestic violence is serious, that the facts of this case were serious, and they gave a 2-year actual suspension. Judge Purcell wrote a concurring and dissenting opinion where she said she would have given a 3-year actual suspension, and she emphasized the acts of dishonesty as being very troubling, that the respondent seemed to be able to lie very easily, and that honesty is very important to the profession. So I would read both decisions if you have a domestic violence case. The court talks also in this case about a number of the prior assaultive type conduct cases from years ago, Stewart and Hickey and Otto, and talks about why now societal values have changed, and that can make a case that wasn't moral turpitude at one point moral turpitude. So we also tried to get the case deemed moral turpitude per se as a domestic violence case, and I believe our office is still trying to do that. My personal opinion, which is not the office line, is that this isn't a situation of moral turpitude per se, but there are very bright minds in this office that would differ with me on that and think that a 273.5 should be moral turpitude per se. One of the reasons for that, interestingly, is there's a decision from the Department of Real Estate, involving the Department of Real Estate, where domestic violence was found to be moral turpitude. And so it may be that this is something where the Supreme Court has to resolve this issue. We are petitioning the Supreme Court for review, and I believe in the hearing judge's decision and the review decision, they said, we have historically treated domestic violence as not being moral turpitude per se, but it may or may not be, depending on the facts and circumstances. And they've said, one of them said in the footnote, this is an issue for the Supreme Court. So maybe the Supreme Court will be interested in seeing that. I think whether or not it is moral turpitude per se, in this case, there's no doubt this was moral turpitude, and it warranted significant discipline. So it's a good read, just in terms of the history of assaultive cases and why we should treat domestic violence differently now than we did 20 or 30 years ago. So I encourage you to read both the hearing judge decision and the review department decision. Are there any questions or comments?
I'll interject one fact that I think this is the case where this prank that he did where he pretended to be the CEO, the reason this was found out was because the girlfriend called the HR department of the company and said, "What the heck is going on over there? Your CEO is sending me these messages." And they called the CEO into the HR and said, "What the hell's going on?" And he's like, "That's not me." So they realized it was the boyfriend, and the cops went out there to visit him and visited him, and they didn't. They said, "Don't do that." But
Any other
that's it.
questions or comments? All right, let's talk about in the matter of Lisa Mackey. I promised we would get back to this. This was Brandon Taty's case on review, and also Alex Hackert argued it on review. And I think Kevin Bucher and David Eichbabo had it at trial. In this case, the respondent intentionally misappropriated $300,000 from a couple of clients and issued NSF checks from her client trust account. The respondent cleverly in this case, because she was probably dead to rights based on the evidence, admitted everything, including culpability. And so when she got disbarred by the hearing department, she came in and said, "Look, I've got all this great mitigation, community service, pro bono work, candor and cooperation. I admitted culpability. I admitted the misappropriations, character evidence, do something less than disbar me," is basically what her position was on review. The hearing department, and the big piece of mitigation that's interesting here that she was trying to claim is she was bipolar, and she had been treated for bipolar effectively for many, many years. And then following the treatment, she had some chemical changes so that she was unaware of the problems, and her medicine needed to be changed. So during the time this money was taken, this was a whole big confusion. So her position was this was mitigating and this conduct wouldn't happen again, and so this shouldn't be a disbarment case. And what the court basically said, both the hearing department and the review department agreed she should get no mitigation for emotional difficulties, physical or mental disabilities. Because in order to get those, she had to show that she suffered from them at the time of her misconduct, that expert testimony establishes they were directly responsible for the misconduct, and that the difficulties no longer pose a risk that Mackey will commit future misconduct. The facts were that she had she claimed an unexpected adverse reaction to her prescription of psychotropic medications that severely impaired her cognitive functioning. So the problem was, though, that the court found that her behavior was inconsistent with the confusion, and that was based upon the hearing judge's detailed analysis of bank records, and Mackey's other actions. So what the review department said is, as the hearing judge noted, Mackey was able to move large amounts of money in and out of her client trust account during the relevant times. She also conducted other litigation activities. She admitted to one client she messed things up and was sorry, which showed she was cognizant. And she also had doctor letters. I think she had 5 different doctor letters, but the letters were really pretty weak. So one of them was a 1-page letter from a psychiatrist briefly stating she was partially disabled due to mental illness, and it wasn't during the time of all of the matters involved. One was a 1-page letter from the same psychiatrist saying she's compliant with her therapy and that her inadequate medication may have contributed to her disability. and that she's been in full remission since. But the problem with that letter is that Ms. Mackey committed additional misconduct in another matter that those doctors didn't mention or know about. And so the court said it's unclear what their opinions would be if they'd known about this other evidence. There was also a pre-litigation evaluation from Richard Sandor, and he's been used as an expert in a number of state bar cases, stating that Mackey's judgment was impaired by her bipolar disorder when she misappropriated the funds, that she made restitution when her condition improved, and her judgment returned, and she's now functional. So what's the problem? Again, Dr. Sandor's opinion did not take into account one of the clients she misappropriated money from, and the hearing department noted that. So his opinion might have been different if he'd known about subsequent acts of misappropriation. There was also a one-page letter from a treating physician who treated Mackey for 4 months, stating that her ethical failure was likely causally related to cognitive impairment from a side effect of her medication, and another one-page letter confirming that she had attended weekly therapy sessions. So the court's conclusion was it is absolutely clear Mackey suffered from bipolar disorder. We're not saying that's not the case, but neither her testimony nor these expert letters clearly and convincingly established that the condition was directly responsible for her misconduct over these years. So it's an important case in that sense. We often talk during these trainings on review department cases about what kind of, what level of knowledge or intent you need in order to commit a misappropriation. And anything from gross negligence to recklessness to intentional conduct will support a 6106 misappropriation, but how much discipline you're going to get in the case is going to depend on the level of scienter of the attorney involved. And so in cases like this, even without the medical issues, we've often emphasized in our office looking at all the facts and circumstances surrounding the misappropriation to show, at least circumstantially, that the attorney knew exactly what was going on when the attorney was taking the money. So looking at how the bank account was being handled, other transactions in the account that might not relate just to this misappropriation that we're looking at can provide keys to the attorney's state of mind regarding the handling of that account. And that is Mackey, unless there are any questions or comments.
Well, her experts probably would have changed their mind if they had known about the 10 other cases we had abated on her.
Oh.
A lot of her other angry clients showed up to the oral argument for that one.
Oops. So the next one is Weiss.
All right,
Manny?
Alrighty, that's me. We're an hour and a half into this, and I'm sure that you are all thrilled to be here. But I'm going to continue. We have a few more minutes. I don't think we're going to do the 2 full hours. I'll start moving here. Mogee Weiss was a case that I argued in the review department. The hearing department recommended that he be disbarred, finding 7 of 9 charges of misconduct. The misconduct concerned 2 matters, one of which was a property matter that a client had, and another was a conflict matter in which he represented people who were adverse to a former client of his. The hearing department found moral turpitude, breach of fiduciary relationship duty on the first matter, misappropriation and failure to maintain funds in trust, among other charges, when there was a property transaction. The transaction included other property transactions, but this particular property transaction was one of a couple. And the first one, there was a agreement between the attorneys and the parties that the funds would go into opposing counsel's trust account. And respondent in the subsequent one wrote almost exactly the same kind of agreement, but never pursued the funds. In fact, the property was owned by his client, even though it was part of a partnership, and the client actually collected the $60,000 that were issue here that respondent was supposed to keep in trust. Respondent never got the money, never sought the money, and when the other side realized that the property had been sold, they went to respondent and said, "Where is this money?" And respondent got half of it back from his client, and then basically misappropriated it. His defense was that he had asked respondent's counsel if he could take the money since respondent's counsel was determined to get the full $60,000, and incredibly the respondent's counsel says, "Oh yeah, go ahead, take the $30,000. I'm gonna." That was one of his defenses. The other, and I think the more interesting one, was involved him representing, and this was also a property issue, a client. Two clients come in, they're adverse to a former client of his, and the reason this is interesting is not the fact so much as the fact that, and I have to thank Alan Blumenthal for this, because the relationship with a former client was not one where there were necessarily discrete periods of representation. He would get legal advice through emails. There were a couple of times he did represent him in short matters, but the relationship was much more tenuous. And we had argued that that even though the relationship was not a continuing or necessarily repeated specifically, but was more tenuous, that there still was a relationship there. And we cited a case in a civil matter, actually, and this is where Alan comes in, Shepard, Mullen, Richter, and Hampton versus J&M Manufacturing, that was decided in 2018. And that case had held in the civil matter that, excuse me, while I dismiss this and start again. Basically that whether or not the attorney-client relationship existed, of course, was based on the reasonable expectations of the client, which has been held before. But when that relationship had ended, the attorney-client relationship has ended, is subject to whether or not the client reasonably understood that the representation had terminated. And that court had said that where a law firm and a client have had a long course of doing business, calling for occasional work on discrete assignments, courts have generally held the fact that the firm is not performing any assignment on a particular date and may not have done so for some months or years does not necessarily mean that the attorney-client relationship has terminated. So it makes it much more friendly and much more onus on the attorney to communicate, hey, I don't represent you anymore and this relationship is over, where you have these continuing representations coming over over the years. That's pretty much the takeaway. Alan, did you have anything to say about that case?
Well, two things that come out of on the conflict one. One is that, which is that it gives us some more legal principles in which to argue that there is, in fact, an existing attorney-client relationship. And not only what used to be 310, but also 3300 possibly violations. Second, on the conflicts, they did reaffirm that where there's a substantial relationship between there will be a presumption that confidences were disclosed. So that was good. The bad part of that opinion is the confidentiality part. And in the confidentiality part, the hearing department found that he had breached confidences by this conversation in terms of telling his new client. The review department said no, because they didn't believe in the 3 or 4 minutes of the conversation that the client could have disclosed confidences, so they speculated. So that was really bad. And the other part of it is, part of their analysis for that is because the new client secretly heard the old client on the telephone conversation. And to me, that's almost per se a disclosure of confidences. If you don't know that somebody else is listening to your conversation with your attorney, that's the problem.
I think that was a kind of a fact-specific thing in that the client was, I think, in Afghanistan or someplace far away. He called, and there was testimony that there was a conversation. And to defend himself that there was no confidences exchanged, the respondent basically said, well, there are no confidences exchanged, and here's my witness, which happened to be the conflicting party, sitting in without, during a telephone conversation on speakerphone, without informing his former client that he was there. So that's what Alan's talking about. We lost on that one, but I don't think that the review department necessarily got that wrong, because the facts were very difficult in that. The record was not very clear in that. It could have been made clearer, I think, maybe. I'm not going to second guess a trial attorney, but it just seems that the facts there were a little more nebulous than not.
Just so you know, respondent has requested petition to the Supreme Court, and we filed about 2 weeks ago a response to the petition.
Excellent. This disbarment was upheld, but some of the counts were dismissed. Okay, moving right along. And we're running out of time here, so let's get through these pretty quickly. Kim, do you want to go over the notice drafting tips and
Sure.
practice pointers?
Sure, the first case, I'll just mention briefly, because we've talked about it a lot, is Lingwood. And as I mentioned earlier, Lingwood, if you don't recall, is the case involving the attorney acting as a trustee and taking out a personal loan of $60,000. In that case, the review department looked at our notice and wanted to know, and maybe Manny can fill in on this more because he actually did the oral argument on this case, but I think they were concerned about an inconsistency because we had pled a loan of $60,000, and we had also pled that the attorney misappropriated the $60,000. Is that right, Manny?
That's correct. The first two charges, I think, the first one was misappropriation and the second one was a 3-300. So by implication, we're arguing she stole the money by taking the $60,000 without permission, and then the next one we're saying she engaged in a business transaction without doing the prophylactic remedies of 3-300. This was a very hard oral argument. This was probably the hardest oral argument I've ever had, and I was at one point literally just silenced for like 30 seconds, just flat, trying to think about how I was going to respond to their questions. They wanted me to basically say that if you have a loan, then how do you have a misappropriation, and to concede that there was no misappropriation, which I was unwilling to do because as I believe today, there was a misappropriation, and that at best the second charge, 3-300, would be a lesser included, but I was, and it could be argued in the alternative. But that's correct, basically, that they found a problem with the notice. They found that the disconnect, or they thought was a disconnect, I'd still argue it isn't, that if you're going to argue a misappropriation, then how can you argue that she failed to use the prophylactic remedies of 3-300, former rule 3-300. And
on this issue, the one thing I would say is it's not uncommon for when we are claiming misappropriation for respondents to say, oh no, it was a loan. So you will have to think about whether you want to charge both or pick which theory you believe is the correct one.
This goes back to them taking, the review department taking a very analytical view of the NDC. Whereas I think we've traditionally in the last few years have said, hey, this is just giving them notice of the issue broadly. They're taking a very technical view of it, and I don't think that actually our notice was deficient in any way. But they took a different view.
Right, so my comment is just, were you finished, Manny?
Yes, ma'am.
Okay, so my comment is just be careful when drafting your NDCs and think about, are we charging inconsistent theories? If we're doing so, why and how? Do we want to communicate to the court the reason for doing that that's a logical reason? And I wouldn't just give up on charging 6106s and 3300s, because back in 2008, I know a lot of you weren't here then, but I remember this case when I was a newer DTC, and the office was astounded over it because we had gone to trial charging an attorney with a 3300 for obtaining a pecuniary interest against a client, and also for a 6106 overreaching or breach of fiduciary duty against the same client. And the hearing judge found the 3300 and dismissed the 6106. And I don't remember if we sought review or the other side sought review, but the review department promptly dismissed the hearing judge's 3300 and found the 6106. So I think sometimes we do want to charge multiple charges, and we don't necessarily want to shy away from that if we have a good reason to do it. And I think in the situation of Casey, I'll give you the site if you want it. It's 5 Cal State Bar Court Reporter 117. In that case, the theories for sure were not inconsistent. They could exist together or separately, depending on the facts and circumstances of the case. So I think a lot of times when we have a 3300 violation, we should be charging a 6106. And it may not be a misappropriation again, it may be an overreaching breach of fiduciary duty kind of a charge that may be more palatable to the court in that circumstance. One of the things we'll talk about at the end is another interesting development this year has to do with duplicative charges, but I'm going to save that for the end, and I think someone else is going to discuss that. Another thing that came out of the Lingwood case is when charging 3300 violations, the terms fair and reasonable are only one aspect of a 3300 violation. The review department thought we got the elements of the violation confused. So if you have a 3300 violation, read the new Lingwood decision, and it's footnote 10 where they discuss that on page 7 of the slip opinion. And fair and reasonable is only one aspect of the charges. Along the lines of that, there is one concern out of the Lingwood case. I think Alan Blumenthal mentioned this, that you guys should be aware of. Footnote 11 talks about the fact that Lingwood acknowledged her 3300 violation, but she claims that the terms of the loan were fair and reasonable. There was no clear and convincing evidence produced at trial as to whether the terms were fair and reasonable. And Alan, correct me if I'm wrong, but I think your concern was it sounds like they're almost shifting the balance or shifting the burden of proof to us to show that a transaction is not fair and reasonable, where that's the attorney's burden that we're prosecuting. Is that right?
That's correct. They shifted the burden, or at least appear to have shifted the burden. The case law is clear from the Supreme Court and the Review Department in past cases that it's the respondent's burden to show that the transaction was fair and reasonable. It's not our burden to show it was not fair and reasonable.
So did you guys all hear that over the sirens? It's not our burden to show fair and reasonable. So we did talk about taking this case up at one of the senior attorney meetings, and we aren't, or this is one we're not taking up, or we are? We're not taking up, right, Alan?
No.
Okay. But that footnote does seem to be wrong and contradict other case law. It may be a slip of the tongue from Judge Hahn there. The other thing is the Chance Gordon case talks about pleading. That's the one that's the loan mod with the partnership with non-attorneys and sharing fees and threats to state bar employees. In that case, the respondent was not found culpable of a violation of Business and Professions Code 6068A, where the NDC alleged that he failed to support the Constitution and federal law by accepting advanced attorney fees for residential loan mod services for out-of-state clients in violation of this MARS rule. And I don't know if that rule still exists or not, but the point is that the MARS rule apparently is hundreds of pages of legislation, and the court referred us back to Rule 5.41B of the Rules of Procedure and said the notice of disciplinary charges needs to cite the statutes, rules, or court orders the member violated, contain facts in concise and ordinary language comprising the violations in sufficient detail to permit preparation of a defense. So a blanket allegation that respondent violated the Mars rule didn't comply because it didn't specifically or adequately cite the rule or rules that the attorney failed to support. The Gordon case also talks about,
Kim?
yes?
Kim, as far as I know, Mars is still valid. I'm pretty sure it's still valid law.
Okay, so if you have out-of-state loan mods, you may want to look at the Mars rule. That's another thing I learned recently. The Gordon case also discusses the issue of charging 6106.3 for a violation of Civil Code Section 2944.7. And again, if the misconduct occurred before January 1, 2017, and an attorney was accepting advanced fees for loan mod, that can be charged under the 6106.3. But there are other cases also that we've discussed in previous years, including in the matter of Golden, which also holds similarly. I want to talk real quickly about another unpublished decision we haven't talked about yet today, called In the Matter of Rita Madisian. And the Madisian case was handled by our outside counsel, so our office didn't handle it. And again, with the theme that Manny mentioned at the beginning of the day that's really important is we need to be careful how we charge things, because the State Bar Court, both the hearing department and the review department, will not help us if we know certain facts ahead of time and we don't include them in our charges. They're not going to let us put on the evidence, and if they do let us put on the evidence, they're not going to find the culpability necessarily. So in this case, the attorney was charged in a notice of disciplinary charges with moral turpitude based on making misrepresentations to a judge and a misappropriation of funds. The review department declined to find her culpable of uncharged misconduct involving tax fraud and breach of fiduciary duties because we didn't charge that and we knew about it at the time. The State Bar has an obligation to connect an attorney's role, capacity, and duties to the misconduct violated. So it's insufficient to simply charge a 6106 violation and presuppose that this includes all of the attorney's dishonest conduct. You have to actually tie the dishonest conduct specifically to the 6106 violation. And the court noted, particularly given the fact that moral turpitude under Business and Professions Code 6106 is such a broad area, it could encompass all kinds of different things. Interesting fact about that case, they dismissed it without prejudice to refiling, but I don't think our office has refiled it, and I think it's handled by outside counsel. So anyway, it's an example. And we had one a couple years ago, I think Brandon Tatey talked about the SAC matter, where the same thing, we had a really bad guy, and he did a lot of dishonest acts, but we didn't charge him with the right ones. And the court hearing department found them, but then on review, the case got dismissed. So we got to be really careful about that. I want to talk about Barwaj again one more time. Barwaj is the crazy guy who tried to file an appellate brief with all kinds of weird abbreviations and sat through a trial where he didn't tell his ex-wife on a spousal support trial or the judge that he had lost his job. In that case, we did, I think I mentioned this earlier, I won't get into details on it. The point of it is the court didn't find a Business and Professions Code 6068A violation for a violation of the California Rules of Court, for violating the, using abbreviations to try to circumvent the rule as to pages for an appellate brief. We have a question?
Yeah, just briefly, Kim, going back to the language distinction, is there some special language that we should be using in our NDCs when we're pleading alternative theories?
You know, I don't know the answer to that.
Could you repeat the question?
Oh, sorry.
The question was,
Go ahead.
the question was, is there some specific language in our NDCs that we should be using if we're going to charge in the alternative?
And I was saying I don't know the answer to that if it's inconsistent theories. I think we need to get some guidance on how we want to do that as an office. I think when you're talking about alternative theories, they're not necessarily inconsistent. So my pitch for these trustee cases is, charge, well, in Lingwood, for example, if she's already said it's a loan, you can charge the loan language, the 3,300, but I think we need to think about, can we charge a misappropriation? And if so, how are we going to articulate that in the notice and in our pretrial statements at trial and to the review department later on if they say, wait a minute, this is inconsistent? I do not know the answer to that. But I think that if we charge a 6106 breach of fiduciary duty, which we did in Lingwood, that's not inconsistent, because by taking the loan, whether you believe she took a loan or not, she took the money in violation of her fiduciary duties. So in that sense, those two charges are not inconsistent. Now, I could see situations where maybe you want to charge, and I have done this in some of these cases. I think in the Renee Campbell case, which Alex is going to be handling on review, we charged 6106 breaches of fiduciary duty for theft of funds. We also charged a misappropriation and conversion of the theft of funds. So I think sometimes you want to have all bases covered, and I don't think they're inconsistent there. The court could find one or the other or both in those circumstances. And then I forgot, your question actually made me go back to what Alan Blumenthal was saying earlier. One of the things that comes up a lot in our cases is there are times where we don't know what the respondent's going to say at trial. So for example, in Lingwood, say we didn't know about this loan she was going to claim. We just know she stole the money, and that's what we're going to charge. We're going to charge a misappropriation and breach of her fiduciary duties as a trustee of the trust. And then we're in the middle of trial, and all of a sudden she says, oh, this was a loan, and I was allowed to do self-dealing under the terms of the trust. Then we're faced with, now we have this new information, and if the court believes it, we lose on the misappropriation, or maybe the breach of fiduciary duty as well. But we haven't charged the business transaction. So those are very difficult questions, and I don't know the answers. I think it's going to be a case-by-case basis.
Okay, Alan, did you have something to say?
Yeah, I wanted to just add to that Lingwood is actually a perfect example, because you could also charge 6106 for the fact that the transaction was not fair and reasonable. Most of the case law where we've charged the 6106 because the transaction was not fair and reasonable, they have found it. It's not 100%, but so you might want to get belts and suspenders by doing something along those lines.
Yeah,
Yes, ma'am. This is Esther Rogers now talking.
I would like to say, from the point of view of us who are actually doing the charging,
Yes, ma'am.
it would be very helpful to have some guidance.
Could you speak up, because you talk so low? Go ahead.
is that sarcasm? We
Some
hear her
guidance
fine
from-
over here.
Yes, that's sarcasm.
We'll take care of Manny later.
I'll take care of it.
Guidance for what?
So we've had, because of the changes I feel like we're having a little shift in the review department now, and the appellate team studied this. I think it would be helpful to figure out some guiding principles that we all should be using or should be alerted to. My fear is everything you're saying, I believe that we did in Bradshaw, and we still got blanked by the review department. So I don't know. I don't know what we can be doing differently or how we should be doing it differently. But I think because we invest so much time and energy in these cases, we have to decide who our audience is and also what we can do to have a greater likelihood of success.
Well, let me just say that regarding Bradshaw, in my opinion, it is an outlier case from the review department. The fact of the matter is that there were several layers of review into charging it, and through the review department with a disbarment. I think that you can't take that as part of a pattern, because it's just, in my opinion, and others can disagree, the review department just got that one wrong. And I'm not saying they do it on all cases. They took a strange view of the evidence in that, in my opinion. So I think that what you're saying is more guidance is great. I don't think it's going to help in that situation. That's my point.
And I'm going to disagree.
I'm going to interrupt you.
I'm going to say it's not an outlier. I think we're seeing these kinds of cases, and I think management is working on. We're trying to get a grasp around all of these cases so we can help everybody figure out how best to try them. And then Kristen had a point down here, if she can raise it. Kristen Ritzema.
In the situation that Kim mentioned, where we charge the breach of fiduciary duties and/or misappropriations under 6106, and then at trial for the first time hear some excuse or story about it being a loan, if it looks like the court is buying into that, you definitely should move to conform to proof at trial. You can do it orally. I've done it and had those granted. At the very least, you make the record, try to get the court to allow you to amend to conform to proof, and if they don't, then you can move to arguing it in aggravation in some way as uncharged misconduct, given that it came out of respondent's own testimony.
Right, which is a whole other training
Can you
issue.
summarize that?
Summarize it? Kristen was saying
Quickly.
Real quickly. Kristen was saying that if you're in trial on a case where we've charged a misappropriation, for example, and all of a sudden the attorney says it's a loan and we didn't know it before, the proper thing to do is to move to amend to conform to proof, I guess, to say, well, in the event that the court believes this crazy story that it's a loan, then we have proven this at least. So by doing that, you put the respondent on notice. You avoid the due process issue. The respondent can now respond to that claim. If, for example, the court doesn't allow you to amend to conform to proof, you can seek to use it as uncharged misconduct, assuming you prove some other counts of culpability or some other form of aggravation, dishonesty, lack of candor, indifference. Anyway.
Thank you.
To you, Manny.
Alex, you told me that you could speak really fast. We were about to run out of time, so
Sure.
Go ahead and cover this last topic in
Right.
detail, but very quickly.
Yeah, very cursory. In the past, we've seen the review departments, obviously give a lot of deference and weight to the hearing department's credibility findings, and tried to push them away from that. And now they, as we see in the Bradshaw and Lingwood, not to get into the facts again, so beat that horse to death. They just eviscerated the hearing judge and saying, your credibility findings weren't adequately supported to what you were, identifying in your basis for these. So, we were chewing this over yesterday, preparing for this presentation, and we think the only real practical point we can give you guys is, perhaps, if that's a clear issue for you at the close of your case, make the necessary arguments you can in your closing arguments and brief it for the hearing judge, at least tee it up. And hopefully the hearing department has gotten the message that their credibility analysis needs to be more detailed to satisfy the review department. So that's all I'll say about that, so we can actually go to lunch on time.
Do we have one more quick one?
I think we have one more quick one.
Yeah, the last thing I'll say is the last point here is that oftentimes you'll see in the decisions the hearing department will dismiss as duplicative charges that deal with the same underlying facts and circumstances. The office's position is that the better practice is to argue that don't dismiss the charges, don't give any additional weight in for the discipline purposes. That's decided, you can see here in the 3 cases we cited here. I thank you all for your time, patience, and I appreciate you coming on down. If you have any questions or concerns, we're happy to talk to you afterwards. Thank you. What's that?
Nicely done.
Just to get them.
Taking a combat body class, so I know how to do
Are you really?
it. Yeah.
You can use me as a punching bag anytime, Esther. Well, that's as good as I got. When you don't, like I was telling, you don't have the people that know what they're talking about up here, that you're going to get beat down. No,
I wrote that in the test.
You do?